of Americans to bring lawsuits against a culprit, Chinese government, for the damage done to their family, to our economy, and to the psyche of the nation. The entire world feels played by China. The entire world needs to send a strong signal to the Chinese Communist Party that enough is enough. So what I am contemplating as chairman is having a markup on legislation that would amend the Foreign Sovereign Immunities Act regarding Chinese culpability involving the coronavirus. Over 120,000 people have died, 40 million people have lost their job, and it's been a nightmare for our country and the world at large. We've used the Foreign Sovereign Immunities Act in the past, amended it in the past, to go after people who have done harm to Americans and represent a threat to our way of life. I think the Chinese Communist Party, given their behavior over a long period of time, we should consider whether or not new tools are necessary to change behavior that is so devastating and deadly. I look forward to the hearing. Then we'll sit down among ourselves and see if we can find a way forward. It is now time, in my view, to act differently regarding China because the old way of doing business is not working. With that, I'll turn to Senator Feinstein.
Thanks very much, Mr. Chairman. Today, the committee, as you said, will examine the Foreign Sovereign Immunities Act and China's potential culpability for the COVID-19 pandemic. I feel differently than you do, so this should make it an interesting discussion. Our focus today is on whether China can be held legally accountable for the coronavirus. That is, whether, the Chinese government can be sued in United States courts consistent with the Foreign Sovereign Immunities Act. Under long-standing international law, foreign states are generally immune from lawsuits in the United States and vice versa. Congress codified this general principle in 1976 when it passed the Foreign Sovereign Immunities Act. This law protects China and any other foreign nation from being sued in the United States. But Congress also provided exceptions in the law that allow foreign states to be sued in certain circumstances. For example, Congress provided an exception in the Foreign Sovereign Immunities Act to allow a lawsuit based on a foreign state's, quote, commercial activity, end quote, such as the foreign nation's sale of products within the United States. The law also allows a lawsuit where a foreign state's wrongful acts result in injury or death within the United States. Two states, Missouri and Mississippi, have now sued China, claiming that these exceptions to the Foreign Service Immunities Act allow them to sue China for initially concealing information about the coronavirus pandemic. And let me say, this is the one thing that I think we really need to look into. Was information, in fact, quote, concealed, end quote? I agree that our own government's conduct, what the Trump administration did or failed to do, should also be examined. The actions of the Trump administration may even play a role in whether China can or should be held legally responsible for harms within the United States. For example, how can China be held accountable for decisions made before the pandemic that made the United States more vulnerable? It was the Trump administration, not China, that cut funds for the Centers for Disease Control and Prevention and disbanded an office within the National Security Council that focused on responding to global public health threats. And how can China be held responsible for decisions that the federal and state governments are making now, long after we learned how quickly and easily COVID-19 can spread and its potentially dangerous consequences which we are experiencing today. Mr. Chairman, as of Friday, COVID-19 had taken over 118,000 lives, and it has caused untold economic damage. I understand the committee's interest in looking at questions around foreign sovereign immunity and China's failures relating to the coronavirus pandemic. But we also need to take a careful look at what our government could and should have been doing. Was it better? Thank you, Mr. Chairman.
Thank you. We have three witnesses. The Attorney General Lynn Finch, Attorney General for the state of Mississippi. Welcome. And Mr. Russell Miller, J.B. Stroumbrook, Professor of Law, Washington Lee Law School. Ms. Shamir Keitner, Alfred and Hannah Fromm, Professor of International Law, University of California, Hastings School of Law, San Francisco, California. Each of you have long resumes. You're all very qualified. Thank you for coming to the committee. And who is remote? The Attorney General from Mississippi is remote, I understand. With that, we'll receive testimony from our witnesses and begin the inquiry. Madam Attorney General, the floor is yours.
Thank you, Chairman Graham, Senator Feinstein, and all the members of this committee for the opportunity to appear before you on this important matter. Like the rest of our nation,
Just a second. Any way to turn that down a notch? Yeah, it's just way too loud. It's not your problem. Okay. Let's give it a whirl. Go ahead, I'm sorry.
No problem. Thank you, Chairman Graham, Senator Feinstein, and all the members of this committee for the opportunity to appear before you on this important matter. Like the rest of our nation, and indeed the world, Mississippi has faced and continues to face devastating consequences as a result of the coronavirus pandemic. It will likely take many years to recover from the loss of life and livelihood. Over the course of 3 months, we've seen over 22,000 cases and nearly 1,000 deaths. At its height in May, over 200,000 Mississippians filed for unemployment benefits. Our unemployment rate jumped from 5.1% to 16.3% in just 1 month. And as a largely rural state, our numbers may seem small compared to hot spots like New York City, but to a state with a population of roughly 3 million, this is significant. Those are losses that we can quantify. But we cannot even begin to measure the emotional and mental side effects that this pandemic has thrust upon us. The students who left school one day, only to never return to their classrooms for the remainder of the school year. The graduations, weddings, and birthday celebrations that were abruptly canceled. The family businesses that will not be passed down to future generations. Mississippians, like others, have not been able to visit with their elderly loved ones, many of whom sit in nursing homes growing depressed at their isolation from their children, grandchildren, and friends. We've even been cheated of proper mourning with funerals and viewings unsafe for all in attendance. The people of Mississippi have suffered tremendous loss. And while we appreciate the generous assistance that the federal government has provided, we believe that much of this loss could have been avoided had China acted as a more responsible global citizen. In fact, not only did China fail to promptly inform the people of the world of the seriousness of this strong contagion, they willfully acted to prevent the world from knowing about COVID-19 and to downplay what the world did know in an effort to benefit themselves. China must be held accountable for those actions. They must be held accountable for keeping the world in the dark about the true nature of this public health crisis, using the time that bought them to hoard masks and other personal protective equipment. When the rest of the world eventually needed them, selling defective or substandard PPE at inflated costs. If an American company had engaged in actions like these, attorneys general across the country would be lining up at the courthouse doors to file suit. AGs file these consumer protection suits not only to recover monetary compensation for losses, but also to act as a deterrent against future similar bad acts. The coronavirus has killed, caused serious medical harm, destroyed businesses, and functionally alter the American way of life. We must hold China accountable so that they and all other nation states will know that we will not allow them to act with impunity. And when they inflict damage on the American people, we'll not turn a diplomatic blind eye, but we'll use whatever tools we have at our disposal to seek justice. Thank you for this opportunity to share Mississippi's story with you. I look forward to your questions.
Thank you very much, Attorney General Fitch. Mr. Russell Miller.
Chairman Graham, Ranking Member Feinstein.
Make sure you turn your mic on. There you go.
Okay, there I think we're on. Chairman Graham, Ranking Member Feinstein, and distinguished members of the committee, thank you for giving me the opportunity to discuss China's potential international law responsibility for the harm caused by the coronavirus pandemic. I am the J.B. Stombach Professor of Law at Washington and Lee University School of Law, and I am an experienced teacher and researcher in the field of public international law. Among my publications in that field is the book Transboundary Harm in Public International Law, Lessons from the Trail Smelter Arbitration. And it is my expertise on that canonical trail smelter arbitration that serves as an important foundation for my contribution to this hearing. I support congressional and executive branch efforts to account for the Chinese government's potential international law responsibility for the substantial transboundary harm its acts and omissions may have caused in connection with the global coronavirus pandemic. The trail smelter arbitration announced the applicable customary international law rule. It's sometimes referred to as the transboundary harm principle, and that rule holds that no state may use or permit the use of its territory in such a manner as to cause serious injury in the territory of another state. The trail smelter arbitration also provides a model for a fair and equitable process for determining the Chinese government's international law responsibility. That process would feature an independent international institution before which all interested parties could participate to establish the facts and influence the interpretation and application of the law. There are many reasons why the United States should pursue and the Chinese government should consider participating in a transboundary harm process. In any case, the success of such a process would be enhanced by creating the possibility for civil law remedies against foreign sovereigns in relation to the global coronavirus pandemic, both as a means for securing individual justice and as a means for motivating the Chinese government to engage in international negotiations concerned with establishing its responsibility and settling on potential remedies. Legislation proposed by members of this committee would make those civil suits possible, and I want to emphasize, would commit the United States to an international law process not unlike the trail smelter arbitration. Those are admirable objectives, and I endorse them. I am motivated today by a deep commitment to the global order and to the public international law regime that makes it possible. State sovereignty is at the heart of that global order, and the trail smelter arbitration provided a rule, and it provided an example of a process for enforcing state sovereignty and international law in our interconnected and transnational era. The pandemic originated in China, and there are profound policy and legal reasons for considering whether the Chinese government's acts and omissions were the proximate cause of the pandemic's immense transboundary harm. In any case, the trail smelter arbitration teaches us that the transboundary harm principle can actually do the offending country a great deal of good. In this case, it would advance the health and human rights interests of the Chinese people. Participation in the transboundary harm process would signal the good faith needed for a confident resumption of the world trade regime from which China profits so significantly. And It would bolster China's desire to achieve the status of a responsible, reputable, and respected global power. But most importantly, just like in the Trail Smelter arbitration, this process would hold the Chinese government responsible for the transboundary harm it has done. It would help prevent a repeat of the pandemic, and it would secure some compensation for the Americans who are suffering because of this devastating, disruptive, and deadly pandemic. Thank you, and I look forward to your questions.
Thank you. Ms. Keitner, did I get your name right there?
Indeed.
Thank you.
Chairman Graham, Ranking Member Feinstein, and members of the committee, thank you for the opportunity to testify today. My name is Shemin Keitner. I hold a chair in international law at UC Hastings Law School in San Francisco. I've also served proudly as counselor on international law at the Department of State, where I worked on matters including foreign sovereign immunity. I offer this testimony solely on my own behalf, and I'd like to offer 3 points today. First, the United States has more to lose than any other country by removing the shield of foreign sovereign immunity for a pandemic. And I'm reassured to hear, Senator Graham, that you appreciate this fully. As you indicated, this is a difficult decision to make. Second, private litigation will not bring China to the negotiating table, and it will not produce answers or compensation for US victims. And so I'm afraid my colleague, Professor Miller, is mistaken in the premise of the argument, as is Attorney General Fitch, that such a process in domestic courts would produce the desired result. If it would, we might entirely be justified in having a different balance of a cost-benefit analysis here. Instead, Congress should focus on the inadequate federal response to COVID-19 and on restoring US leadership in global public health. And again, I'm delighted that my colleague, Professor Miller, endorses that goal as well. Now, let me be clear at the outset, I am not here to defend China. My purpose in joining you here today is to help protect the United States. My testimony would be virtually identical if the pandemic had originated in any other country. My points about sovereign immunity are neither original nor controversial, nor should they be viewed as partisan, and I'll address them in turn. First, the United States has the most to lose in removing sovereign immunity for a pandemic. The principle of foreign state immunity does not absolve any country from legal responsibility for its wrongdoing, and that's an essential point to emphasize. It also does not prevent the United States from imposing serious consequences on foreign countries for violating our mutual obligations. It does not compel, let alone countenance, a quote-unquote diplomatic blind eye, as the Attorney General called it. What it does prevent is non-consensual litigation against one country in another country's courts. Instead, we do resolve disputes through diplomacy, including coercive diplomatic measures, and in international tribunals whose jurisdiction is based on consent. Because of our unparalleled global footprint, the United States has the most to lose from weakened immunity rules. And indeed, the 1976 Act that Senator Feinstein referred to does contain 2 exceptions. I'd be glad to explain in questions why those do not apply here. We might be on the receiving end of a virus today, but we could easily be on the exporting end of a different virus tomorrow. My second point, as I mentioned earlier, is that private litigation will not force China to negotiate, and it will not provide answers or compensation. Instead, it will give false hope to US victims and tie us up in years of counterproductive litigation at the expense of US taxpayers in US courts. In addition, recall President Trump's effusive praise of China's initial response, which included thanking President Xi in late January on behalf of the American people. If lawsuits against China proceed, you can be sure that his remarks will be cited in China's defense. This is just one of many hurdles these lawsuits would face. The causal claim, the causal chain, as you have heard, has dozens, if not hundreds, of additional links. In this respect, and in many others that I'd be happy to go into, it is fundamentally different from the Trail Smelter case. Creating exceptions to sovereign immunity, including from attachment and execution, as one of the proposed bills would do, would not compel China to negotiate. But using these complaints in US courts as a lever to force negotiations is like using a stick of dynamite to try to put out a forest fire. As the tireless work of our own public health officials has shown, detecting, reporting, and containing pathogens are routine and essential government functions. These are precisely the sorts of functions that foreign state immunity covers under both international and US domestic law. This brings me to my final point, which is that we must focus on our domestic response and restoring our global leadership. A crisis of this proportion demands that we focus on actions that will help the American people. I strongly support the call for an international independent investigation and for a bipartisan panel, as has been proposed, akin to the 9/11 Commission. Such a commission would show the world that we are confident enough and candid enough to confront a crisis without resorting to the kind of concealment and buck passing more often associated with authoritarian regimes. Thank you, and I look forward to your questions.
Thank you all. Attorney General Fitch, have I got your name right?
Yes, sir.
Okay. Do you feel like the people of Mississippi are to blame, or is China to blame?
Certainly China's to blame and must be held accountable, Mr. Chairman.
So, from your point of view, does this, the Foreign Sovereign Immunities Act, need to be amended at all to allow you to move forward?
Absolutely. Now, we are moving forward because we believe that there is an exception that is already workable, and that's how we're proceeding on our lawsuit, which we filed in the United States Federal District Court of the Southern District of Mississippi. It's important to note that with the Foreign Sovereign Immunities Act, that the exception that is known as the commercial activity exception is an action based upon commercial activity carried on in China that causes a direct effect in the United States, and they may not be immune from the jurisdiction of U.S. courts. It defines commercial activity by reference to the nature of the course of conduct or particular transaction or act, and not by its purpose. And China was engaged in commercial activity, including the production, purchasing, import, and export of PPE, even essentially nationalizing the PPE manufacturing. So we believe this exception is workable, and that's why we're proceeding with our lawsuit. Now, certainly the amendment to the Foreign Sovereign Immunities Act would be extremely helpful, because providing additional exceptions provides us broader avenues for states and individuals to seek justice. There's no reason to restrict the tools in our toolbox.
Mr. Miller, what's your view of the argument she just made, your knowledge of the act? Do you think that the Mississippi lawsuit is justified under the current law?
My expertise isn't as strong in the area of the Foreign Sovereign Immunities Act as either the Madam Attorney General or my colleague, Professor Keitner. My survey of that legislation and the relevant rules led me to wonder if, in fact, there's an uphill battle for the plaintiffs in these cases, both under the commercial activities provisions or the territorial tort provisions. You're going to hear skepticism, I expect, about the functionality of those exceptions in this case from Professor Keitner, but all of that only then points to the necessity for amending the act if we want to move forward with these suits.
So the goal, from your point of view, would be to drive China in a consensual arbitration environment. Is that what you're suggesting?
Well, I don't share Professor Keitner's view that these domestic civil suits are more harmful, necessarily more harmful or futile. We have plenty of evidence that they can actually do what you've just described, Chairman, that they can move our foreign partners towards a consensual negotiation. But we also have evidence that they can turn towards providing actual compensation for American victims in a number of cases. The case against Saudi Arabia, justified under the exceptions opened up by the JASTA amendments, is moving painstakingly through the process, but holds out real promise for securing justice. I can think of one profound example in which civil litigation worked in tandem with the kind of international law processes I describe, and that, of course, is the long and painful story of the Pan Am 103 terrorist attacks. And in that context, civil litigation worked profoundly to move Libya towards a settlement at the international law level.
Well, so my goal is to put as many levers on the table as possible to get China to change, compensate people in a fair fashion. This is the third pandemic coming out of China, and the consequence to our country and the world has just been astounding. So to go back to the old model where you just, I don't know, Ms. Keitner, do you support a pandemic tariff?
Your Honor,
Could you put,
Senator, yes, I just promoted you to judge. Senator, I am not an economist. I do reference in the footnotes of my written testimony a report from the, I believe it's the American Economic Institute, that explains in convincing detail why that would be a terrible idea.
okay, you don't support tariffs, do you support sanctioning China?
Yes, I think in certain appropriate circumstances.
Can you tell me what you would do?
Well, obviously, the executive branch under the International Economic Powers Act has the ability to, and in fact has used that ability to impose sanctions both on a state level
What about
and on an
Congress?
individual basis.
What can we do?
You could give the president further guidance in the types of sanctions you would like to see him impose, as you've done with the Uyghur Human Rights Act recently. And I think those types of levers are the ones that are much less likely to boomerang back than the one that your colleagues are proposing here.
Can you give me an example of where sanctions against China has substantially changed their behavior?
Again, my expertise is not in China specifically, but I would point to the progress that we've made both with respect to economic espionage, although there does seem to be some backsliding there, as well as the trade deal that I was reassured to hear from our
Right.
president this morning is still in good shape.
I'll answer my own question, no. Absolutely no example of where doing anything under the current situation has changed China's behavior. That's why we're having the hearing. Senator Feinstein.
Did you call on me? I'm sorry. I just want to point out that the chairman did not administer an oath, but that the witnesses are under an obligation to tell the truth. I'm
You're
sure
right,
you
I
know
didn't.
that.
I'll swear him in. Why don't we do that? My bad. Stand up. Raise your right hand. Mississippi, raise your right hand too. Do you solemnly swear the testimony you're giving and have given is the truth, the whole truth, and nothing but truth, so help you God?
I do.
There you go. I don't know if that
Thanks,
works,
Mr.
but we'll
Chairman.
try.
On April 17 of this year, a Republican communications firm, I think it's by the name of O'Donnell and Associates, released a memo urging Republicans running for office to blame China for COVID and to shift any responsibility away from the Trump administration's planning for and response to the pandemic. So I'd like to ask this of both panelists. Are you aware of that memo? And if so, how did you learn about it? Attorney General?
Thank you, Senator Feinstein. I am not aware of that document, nor have I seen it or heard anything about that.
Thank you. Could we hear from our panelists here?
I've never heard about this memo, never seen it.
Yes, Senator Feinstein, I've done my homework. I am aware of the memo. I read about it in the press. I then read the memo and found it extremely striking that many of the allegations in the memo are repeated almost verbatim in some of the lawsuits that have been and are being filed.
Before Attorney General Fitch, Mississippi filed a lawsuit against China just days after the release of the memo. Before suing China, did you talk with anyone about the Republican strategy to shift blame to China?
Senator Feinstein, I did not. I believe this legal action is worth taking on behalf of the people of Mississippi. We cannot ignore what China did, and I brought suit under our consumer protection laws. It's important. Again, we are showing that China engaged in unfair and deceptive acts and methods and practices. And China covered up the seriousness of COVID-19. And
Thank
so
you.
we're
I
utilizing this
understand that.
efforts to move forward.
Thank you.
Senator
I have
Feinstein.
another question. Before suing China, Attorney General, did you talk with anyone about the Republican strategy to shift blame to China? Has anyone ever expressed to you in any way, shape, or form they think your lawsuit is a good way to shift the blame to China?
No, Senator Feinstein, not at all.
And you know you're under oath.
Yes.
Okay. I just would like, Mr. Chairman, to know more about that Republican communication firm that released the memo urging.
I can say I've never read it along with everybody else. I figured this out all on my own.
Okay. Here's another question. Does the Foreign Sovereign Immunities Act allow lawsuits against China related to the coronavirus?
Senator Feinstein, if that's directed to me, and I am a reporter on foreign sovereign immunity for the American Law Institute, although of course I don't represent the views of the Institute here today, it does not. That is precisely why amendment would be needed in order to allow suits to be filed, although again, they would not produce compensation. And I would be glad in questions for the record to elaborate extensively on why there are not examples that are relevant that pave the way to the glorious end we're all hoping for here.
I would qualify that, Senator, only by noting that that's a legal question to be determined through advocacy and arguments over the nature of the standards applied in the two exceptions, the commercial activities exception and the territorial tort
With
exception.
respect, Professor Miller, I'm giving my expert opinion as a former State Department lawyer and someone who's written
Well,
extensively
could
on
he
this
finish
topic.
answering?
It's really just a
Question.
determination of law for an Article III judge, not a State Department representative who would, in essence, be a party to that advocacy to settle that question definitively. You asked whether it's possible to sue, and of course it's possible, and the legal standards have to be resolved by an Article III judge.
Thank you. Please continue.
Oh, sorry, and again, just to clarify, I am not here on behalf of the State Department. I haven't worked there in several years, but it did give me insight and experience that nobody else on this witness panel has. What I will say to reassure the Attorney General, if the problem is PPE defects, that could be a straightforward contract-based claim that would fall under a sovereign immunity exception. You can get your money back, but that does not give you a hook to start litigating the public policy of the Chinese disease prevention and regulatory agencies, just as we would not want a foreign country's courts to scrutinize the actions of our FDA.
Thank you, Mr. Chairman.
Thank you. Senator Grassley.
Yeah, most of my questions will be to Fitch and Miller. I'm the author of the Anti-Terrorism Act and its subsequent amendments, so I know how difficult it is for victims in cases against foreign states or entities to get compensation. This is especially true when Congress clearly says one thing, but the courts still do another. I also know the lengths the Chinese government and its agents and subsidiaries will go to avoid U.S. justice. Last Congress, I introduced the state-owned entities Transparency and Accountability Reform Act, which would amend the Foreign Sovereigns Immunity Act to prevent the shell games that Chinese state-owned enterprises play in our own justice system. So here's the first question. If Congress amended the Foreign Sovereigns Immunity to prevent Americans to sue China for COVID-19 damages, are you concerned about the victim's ability to collect in their judgments? And in other words, do you envision victims actually getting compensation from China? Why or why not? Start with the Attorney General from Mississippi.
Thank you, Senator. No, we fully believe that we are moving toward monetary damages and compensation for the state of Mississippi. But again, this is very much about deterrence. Entering into a lawsuit on behalf of the state of Mississippi, we are holding China accountable. They have been a bad actor. They have willfully acted. They have been malicious. And so we intend to not only go for monetary damages for all Mississippians, but certainly to set an example that we will not tolerate this, and by setting an example in a deterrence manner through our lawsuit.
Professor Miller.
Yeah, obtaining compensation for American victims by way of FISA or the Foreign Sovereign Immunity Act is a very difficult prospect. I recognize that. But we have a number of cases in which American victims of unlawful activity by foreign sovereigns can be given compensation, can receive justice. And it's my advocacy today that we imagine how the Foreign Sovereign Immunities Act, as amended by some of the legislation in consideration, in combination with consensual international law leverage, can actually move us towards that goal.
In 2016, I worked with other sponsors on the JASTA Act and recently led two important amendments to my Anti-Terrorism Act of 1992 to reopen the courthouse doors for American victims of international terrorism. Through it all, Congress was consistently told by the foreign policy crowd to not move ahead for fear of this or that reciprocal action overseas, but we nevertheless passed those bills to get justice for American citizens. My first question, I'll start with the Attorney General for Mississippi. Would you agree that Congress acts for the American people and that it shouldn't be swayed by foreign threats or speculative retaliation?
Absolutely, Senator. We should not be swayed by any threats coming from a foreign nation. I think certainly the amendments and adding additional exceptions are important. These are going to provide us broader avenues on how we proceed, and we seek justice for states and individuals. So no reason to restrict and no reason to give in to their threats or demands.
Before I call on you, Professor Miller, let me give another question, and you can answer the two at a time. China has long made clear its intention to aggressively use domestic and international legal systems as part of what it calls three warfares. If China is already using our legal system against Americans, isn't it only appropriate that Americans have full legal recourse against China for its actions and failures? Professor?
Yeah, Senator, thank you. I'm here advocating for us to open up the possibility of American domestic civil litigation as a way of adding leverage to the mechanisms at the international law level, consensual mechanisms that have produced compensation. So I find that a compelling concern. I want to also underscore that it is a unanimous Supreme Court that recently endorsed the kinds of amendments this committee is considering with respect to foreign sovereign immunity and extending punitive damages coverage on the basis of some of the amendments this body has pursued.
May I correct a statement in that testimony, Senator?
You may, yes.
The Supreme Court by no means endorsed the kind of exceptions we're discussing here. It was a question of retroactivity and interpreting this body's choice of statutory language. However, there is a very good basis for distinguishing the terrorism exceptions that I'd be glad to get into if asked.
Okay, I'll yield back, or I'm done.
Senator Coons.
Thank you, Chairman Graham. Thank you to our panel today. There is a broad bipartisan concern about China's early response to the COVID-19 pandemic, and it's also clear that the WHO's initial response was inadequate. However, that doesn't change the reality that in the United States we've seen more than 120,000 Americans die, and an economic crisis at moments rivaling the Great Depression, largely because of a disorganized and chaotic federal response. We should find ways to hold China accountable, but we also must honestly assess our own response and how the administration's actions will or will not bring us out of this ongoing pandemic safely and prepare us for working with the world to address the next pandemic. So, Professor Keitner, if I might, the principle of sovereign immunity is based essentially in reciprocity. If Congress were to create a cause of action.
Thank you, Senator. Well, in the first instance, what would stop them is customary international law, and in some instances, their own domestic immunity statutes. But what would happen, because the United States is a trendsetter and does have a tremendous influence on the development of customary international law, it is not simply a question of fearing threats from China. That is not my concern here. We can stand up for ourselves. However, it will have an effect of eroding the protections that we enjoy in foreign courts, and particularly in the pandemic context, where we don't even actually know for sure right now whether, for example, the influenza pandemic in 1918, where that started, where the 2009 pandemic came from. There are indications it may have been the United States. We don't want to be put on the hook for those sorts of things in foreign courts either.
Are there other recent examples of Congress stripping a foreign government of sovereign immunity where it wasn't related to an act of terrorism, where it wasn't somehow terrorism related?
Certainly not to my knowledge, and I have looked at this issue very comprehensively.
Mr. Miller, are there other examples you can cite recently of Congress stripping foreign sovereign immunity in an instance that did not implicate terrorism?
No, but I would qualify that answer only by noting that the scale of the harm done by this pandemic might justify a departure from that tradition.
What are, Professor Keitner, the diplomatic or economic tools the United States could use to impose costs on China for its lack of transparency, its suppression of information? And has the administration used all of these tools? Have we effectively used our own tools, and have we coordinated with our allies and partners to impose costs?
Thank you, Senator. Again, I think my expertise lies in our use of courts, and on your latter point, we have not effectively coordinated with allies. In fact, my observation, again as a former, not a current government official, is that we haven't done a very good job coordinating among domestic agencies either. So the kind of teamwork that we need, both to impose consequences on China and to solve the massive problems that we're all facing, is something that we need to do through leadership and we need to do together.
So President Trump has decided that we should withdraw from the World Health Organization, that we should stop our financial support, we should withdraw as a member of the agency because he thinks China has too much influence over the WHO. But our withdrawal would prevent us from participating in improving the agency and holding it accountable and making positive changes. And frankly, in our absence, Chinese influence over the WHO will likely only increase. In our absence, having threatened or withdrawn, will you see ways that like-minded nations like the United States could actually lead reform? Or does it strike you as more likely that China will end up having a greater role in response to pandemics, and as a result will end up more vulnerable to future outbreaks?
The absence of the United States from the WHO, if that indeed comes to pass, would be devastating for the health of Americans and for the health of individuals around the world. What we have seen with this pandemic, precisely the scope of harm that my colleague Professor Miller referred to, is that notwithstanding the intent or the scale of the original act, unlike flying airplanes into the Twin Towers, an act of international terrorism on U.S. soil as you defined it in the statute when you enacted JASTA. This is something that could happen. It could come from the United States. It has come to the United States, and we will not be able to suppress or identify these threats if we are not part of the global body charged with doing so.
Thank you, ma'am. Thank you, Mr. Chairman.
Senator Cornyn.
Professor Keitner, where did the COVID-19 virus come from?
I personally have no idea. I've read reports. I'd be glad to recite them to you.
Do you have a security clearance?
It is no longer active.
Okay. So you don't know whether that came from China or not?
Personally, under oath, no, I do not, but I, again, would be happy to recite reports if that's of interest.
Well, you said you had insight and expertise that no one else on the panel has. Does that also extend to the origins of the virus?
It is limited to the origins of the virus, and it covers issues of foreign sovereign immunity, international tribunals, jurisdiction, and diplomacy.
It sounded to me like you were saying that it was the United States government's fault, not China. Did I misunderstand you?
You absolutely misunderstood me, Senator.
Well,
It
I heard
is not
somebody
a
said,
question-
excuse me, I heard someone on the panel suggest that this was part of a Republican public relations effort to shift blame from the United States government and away from China. Do you subscribe to that view?
I have no knowledge of whether or not anybody read the memo. I note Senator Graham's comment that he did figure this out all on his own, end quote. So the motivations here are unclear to me, but the main point remains. China failed in its obligation to the international community. The WHO, because it's an international organization, can be bullied, and the way to prevent that from happening is to be a partner with our allies, to step up and show by example that we are transparent, that we are honest, that we know how to do testing and tracing, and that we can conquer this pandemic together.
Well, I know you know this, but there is a precedent for Congress amending the Foreign Sovereign Immunity Act to provide a cause of action or at least allow American citizens to sue foreign nationals for damages sustained by them on American soil. And of course, I'm talking about JASTA, right?
Sorry, I think maybe there may have been some words in there. We can sue foreign states. Also, at certain points, they're officials for damages sustained by Americans on U.S. soil. Indeed, there is a difference between immunity stripping and causes of action. We can get into that later. But if the question is whether under U.S. law, Congress has the power to do whatever it wants with the FSIA, the answer, of course, is yes.
And we did in passing JASTA back in 2015 or 16.
Indeed, and the reason the sky did not fall is because of the limited language in that statute.
Okay. So Congress clearly has the authority to do that, and I assume would have the authority, in your opinion, to craft a similar narrow statutory exception to sovereign immunity in this circumstance.
Again, I see no dispute about the authority of Congress here.
Okay. Well, Mr. Chairman, my own experience with JASTA was as the lead sponsor for a bill that passed unanimously in the Senate, was actually foreign countries hired lobbyists on K Street to come in and lobby the United States government not to pass JASTA, which again passed unanimously. And I know the ranking member, Chairman Grassley, Chairman Graham, and others are working on some changes to the Foreign Agent Registration Act, which would make it easier for the U.S. government to identify foreign countries hiring American lobbyists to come here and lobby us to change U.S. law in a way that benefits these other countries, but to the detriment of the United States and its citizens. And I hope we can continue to pursue that. I think that's an important piece of this, because we know that China also has been very aggressive in its public relations campaign and propaganda efforts. I think I heard one of the panelists sort of repeat what had been said, that there was some published reports that this actually emanated from the United States. In fact, I think China made the argument that it was actually some U.S. military which was the source of the coronavirus. So this is very
Senator, I'm sorry, just to clarify my testimony, there is no question that this did not originate in the United States. I had understood your question to put at issue whether it originated in the wildlife market, whether it perhaps originated elsewhere in China and migrated to the market. So just so we know, we're on the same page. This virus originated somewhere in China. I just do not know where precisely.
Thank you for that clarification. I appreciate it. Thanks, Mr. Chairman.
Senator Whitehouse.
Thank you, Chairman. I don't know if we're running a Republican Senate campaign committee errand here or not, and I'm not
I can
going to
assure you
pursue
we're
it.
not, and we're going to vote on this bill, and if you want to defend China, you're welcome to do so.
No, I actually was interested in some of the other stuff that's going on at the Department of Justice, which we have oversight over while we're here together. The first is that it turns out the Attorney General has fired the U.S. Attorney for the Southern District of New York. Doesn't seem to be any reason for it. None was stated. It seems to have been pretty rash in that the Department of Justice seemed to have forgotten that Mr. Berman was a judicial appointment, not a Department of Justice or presidential appointment. So when they tried to fire him, they ran into a problem that gave him leverage to impose that his deputy would be his successor and not the Attorney General from New Jersey, which alone is a bizarre circumstance. The U.S. Attorney from New Jersey, nothing against New Jersey, but if you're the Sovereign District of New York and suddenly you're told that you're going to be run by the U.S. Attorney from New Jersey as a part-time effort, something bizarre is going on. When you haven't figured out that Mr. Berman is a judicial appointee, something bizarre is going on. When you haven't figured out that this committee still enforces its blue slip on U.S. attorney nominees, so you think you're going to put Jay Taylor in without realizing you have to go through Chuck Schumer and Kirsten Gillibrand to get there? I mean, this is fire the associate quality preparation. Something weird happened in the Department of Justice to cause knucklehead stumble-bum errors like that to be done by the Attorney General of the United States. And I submit we'd be better off spending our time looking into what that was. And here's another one. We had Mr. Delrahim, the head of the Antitrust Division, here for a hearing. We asked questions about a patently preposterous antitrust investigation that he had launched that happened to align extremely well with the political interests of President Trump and of Marathon Petroleum, which was trying to bust up the California fuel efficiency standards. So we got nothing in the way of serious answers at the hearing. So I followed up with QFRs, and as you all know, questions for the record have been, I think as a matter of policy, ignored by the Department of Justice, whether they come from my side or your side. So we got no answers to our QFRs, so we sent a follow-up letter saying, what's up with the QFRs? No answer to that. So I put a hold on a bill that the department wanted, and suddenly I got a little bit of their attention, and I brought it to the chairman's attention, and to his credit, he brought the Deputy Attorney General over to sit down and talk through what the heck is going on with all the questions for the record and all the letters that the Department of Justice isn't answering. I mean, by the dozen. This is a pattern. This is a practice. Well, why would they be avoiding answering questions about this antitrust thing? While we're doing this, they're having a hearing over in House Judiciary right now on what's going on at the Department of Justice. And here's the New York Times reporting from just minutes ago about the whistleblower from the Antitrust Division. His name is Elias. And the report is, Mr. Elias's statement also portrayed an antitrust review, the one we talked about, of a deal struck by 4 major automakers with the state of California to voluntarily continue to improve fuel efficiency and reduce emissions on new cars, despite the Trump administration's rollback of federal standards, as politically motivated rather than grounded in the facts and the law. Mr. Trump had attacked the deal on Twitter, and the division began its review without going through normal procedures, Mr. Elias said. Quote, the day after the tweets, Antitrust Division political leadership, the guys who sat right there, wouldn't answer our questions, instructed staff to initiate an investigation that day, he wrote. Something is very wrong at the Department of Justice, whether it's Mr. Delrahim and his antitrust division that is running political errands for President Trump against America's auto companies, or whether it's U.S. attorneys who are investigating Trump associates be fired without apparent reason in such a cluster mess that they managed to overlook that he was a judicial appointment, managed to overlook there's a blue slip, managed to lie twice. Either Barr or Berman is lying about whether there was an agreement Berman would resign, and either Barr or Trump is lying about whether Trump ordered the firing. Trump said, I had nothing to do with this, after Barr put it right on Trump's shoulders. So you got 2 lies floating around out there that haven't been assigned to the individual liar. You got to admit, guys, this is weird. This is not the Department of Justice that America counts on. And my time has expired. I apologize for going over a minute, but you got to admit, this is weird.
Well, if you want to hear weird, we'll tell you about Loretta Lynch and all those other people. So I think there's a lot of weird going on. But the blue slip process will stay in place. There's nobody coming to be the Southern District New York U.S. Attorney that doesn't get blue slip returned. That's been the policy of the committee. That will not change.
We appreciate that, Mr.
Yeah,
Chairman.
well, that's just...
Thank you.
You don't need to thank me. That's just a fair way to do business. As to the number 2 in the Southern District in New York, I have all the confidence in the world. She'll continue to do her job. In terms of firing Mr. Berman, there's certainly the ability to do so, and it was used. And if somebody suggests it was done inappropriately, we'll call Mr. Horowitz and let him look at it. But we're going to still keep talking about China. And with that, I think Senator Hawley, is that right, Senator Lee? You want Senator Hawley to go ahead? Is that Okay, Senator Hawley, are you there? Senator Hawley's not there, okay? Senator Lee.
Thank you very much, Mr. Chairman. Thanks for holding this hearing. China has what we might describe fairly as a long and very disturbing history of civil rights abuses, including civil rights abuses against its own citizens. This is a pattern of abuse, really, and it's one that is somewhat startlingly evident, even in the airbrushed picture that we've been given from China on its personal, on its own internal reaction to the COVID-19 global pandemic. Perhaps most egregious are the reports of China's quote-unquote sealed management of the virus, which led to Communist Party officials welding the inside of welding people inside of their homes and apartment buildings. This is not something that a responsible government does. This is something that we should not countenance in any way. But as barbaric as that is, welding people into their homes, it's just the tip of the iceberg. I think somebody over there might have their microphone on. Even though the Chinese government knew, or at least strongly had reason to suspect, that the virus was spread by human-to-human contact, Wuhan Dr. Ali Fen was disciplined for ordering her staff to put on masks. Dr. Wenling, another Wuhan physician, was also punished by the Chinese government, in that instance for trying to warn others about the deadly nature of the virus. Unfortunately, Dr. Wenling lost his life to COVID-19. The evidence suggests that as early as December 31st, China could have taken reasonable preventative measures to protect the rest of the world from this pandemic. Instead, China repeatedly lied to its own citizens. It lied to the World Health Organization, and it lied to the rest of the world about the nature of the virus, about the extent of the spread, and about the rising death rate and infection rate within China. The Chinese National Health Commission even went so far as to outlaw publishing information related to the outbreak. Now, this is the Public Health Commission, whose job it is, supposedly, to protect public health within China. The effort to cover up the severity of the situation extended beyond Wuhan and across China's borders. It's a problem inherent to communism. Eventually, the propaganda and the political whitewashing become deadly, and did in this circumstance. Based on representations from Chinese officials, the World Health Organization, quote, did not recommend any specific measures for travelers, close quote, and even went so far as to advise against any travel or trade restrictions on China. In fact, the World Health Organization, which itself failed to conduct its own research and instead mystifyingly relied on representations from China itself, did not raise any alarm bells until January 30th. And yet, as much as a week earlier, on January 23rd, Chinese officials shut down domestic flights out of Wuhan and surrounding municipalities to avoid spreading the virus throughout China and within China. This is alarming, considering that they continued to allow international flights and thus allowed virus to continue to be spread until March 29th. Thank goodness that President Trump restricted travel into the United States from China as early as he did, or the situation would have been much, much worse. Professor Keitner, I'd like to start with you. In written testimony, you acknowledged that China's damning actions and omissions. Do you stand by that statement?
Absolutely, Senator. As I indicated, I am not here to defend China's actions.
I appreciate that. Attorney General Fitch, if under current U.S. law, if we lack civil jurisdiction over China in this instance, what other avenues of relief are available to us to allow us to hold China accountable for lying to the World Health Organization and to the rest of the world, and for failing to take precautions to prevent the spread of this virus across the world? There you go. We can hear you now. Thanks.
Thank you, Senator. We certainly will proceed with our lawsuit based on the exception that we've discussed. Any additional exceptions are very important. You know, the world today is very different from 1976. So no law should be absolutely static. So it's an opportunity to amend these laws and to give us other tools. But to your point, Senator, in ways that we really can't understand as a free society, to see these doctors, these medical experts that were forced to confess to crimes, to prepare self-criticisms and stop committing unlawful acts as they were made to do. You know, we looked at it, we saw the social media, it was censored. We know that these are bad actors in China, and we've got to hold them accountable. So we'll move very readily on our lawsuit with the exception at hand, and we look forward to any other additional exceptions brought through the Congress.
Thank you, General Fitch. Mr. Chairman, could I ask one more question?
Absolutely.
Thank you. I appreciate that. I've got a question for Professor Miller. As a member of the World Health Organization, I'd like to know, first of all, what duty China might have had to accurately report information to the World Health Organization. And related to that point, if China did, in fact, knowingly mislead the World Health Organization, under that agreement, what action can we expect the World Health Organization to hold China accountable?
Senator Lee, I'm sorry I won't be able to answer that question. I'm not fully versed on the obligations states confront as part of their duties to the World Health Organization or their participation in the World Health Organization. I can say that there is a spectrum of public international law commitments to which the United States, also China, are responsible for fulfilling that range from global health concerns to human rights concerns, like the important issues you raised, to security concerns, all at the international law level, which should be implicated here as well. But the details of obligations under the World Health Organization regime, I'm not competent to comment on.
Okay.
I'd be happy to chime in if you'd like, Senator.
That's okay. Senator Blumenthal.
Thanks, Mr. Chairman. I want to join in expressing my appreciation to the chairman for adhering to the blue slip policy, but also his suggestion just now that if anything inappropriate occurred with the dismissal of United States Attorney Berman, that we should ask for further inquiry. I'm going to suggest to the chairman respectfully that we should ask Attorney General Barr to appear before this committee. He promised, literally sitting right there during his confirmation hearing in response to questions from me, that he would not fire the United States Attorney in the Southern District of New York. He promised that he would not dismiss that prosecutor for anything but some discernible and provable misconduct. In effect, he made that commitment. So I think he has raised very severe questions about his truthfulness under oath, and he was under oath in that proceeding. I've written him today.
Senator Bloom, I don't mean to interrupt. Can you get me that from the record? I'd appreciate that if you could.
I would be happy to, Mr. Chairman. In fact, I've included in a letter that I wrote to Attorney General Barr today, asking him for an explanation in writing. I'd be glad to provide it to the chairman, and I, again, appreciate his interest in this matter and his willingness to adhere to the blue slip policy. I want to say the issue has been raised about a commission. I think you raised it, Professor Kite. Actually, I proposed legislation to establish a commission, objective and independent, completely nonpartisan, to look back and learn lessons, because we have to learn lessons from the mistakes that were made and, frankly, the misconduct that may have occurred. And the Chinese are far from blameless. Their concealment of the true magnitude of this pandemic no doubt contributed to the scope and scale of the loss. And at the same time, the administration downplayed the need for preparedness, in fact, fired the team that was responsible for pandemic response. It dismissed early evidence about the magnitude of this insidious, deadly disease. It delayed use of the Defense Production Act. It denied the need for testing and masks and gowns and face masks, other kinds of preparedness and vaccines and therapeutics. So there is a lot of blame to go around, but that kind of commission ought to be established at some point so that we can learn lessons. I want to say to the Attorney General of Mississippi, I certainly admire any Attorney General who is willing to battle the odds in court. And my mind goes back to my own experience with attorneys general, a post that I held for 20 years, in particular, my joining the then Attorney General of Mississippi in a lawsuit against the tobacco companies that everybody said could not be won. They gave us no chance in court, including then the United States Department of Justice, which would not join us in that lawsuit. So I encourage you to continue an uphill battle to vindicate the rights and losses of the people of Mississippi and any other Attorney General who joins you. And let me just ask you a couple of questions. I take it that you are not here, Attorney General Fitch, to say that a change in the law is necessary for the success of your lawsuit because you fit within the exception of the commercial activities law of the Foreign Sovereign Immunity Act. That's correct, isn't it?
Yes, thank you, Senator. It is, and we certainly would appreciate any additional avenues and tools that we can move forward. And thank you for those words. I mean, I take all of our litigation serious. I'm acting on behalf of all Mississippians, and we're looking for justice. That's why I'm proceeding with this lawsuit against China.
Thank you.
And to your point, thank you for the commission to review. I think that's extremely beneficial, and I appreciate moving forward on that. But if we can hold them accountable now, that's exactly what we should do.
And you are not relying on some of the published reports that I have seen, including from the Secretary of State, implying that the coronavirus might have been produced in a laboratory in Wuhan and allowed to escape by the Chinese. That's not part of your claim, is it?
No, my claim, Senator, I'm proceeding on my lawsuit under the Mississippi Consumer Protection Act and the Mississippi Antitrust Statute.
Well, that's a good thing because I can tell you from my review of the intelligence here, and I think it has been acknowledged by most scientists, there is no evidence to support that kind of claim so far as I know. But that is not to say that China does not bear some blame here. And I just want to read you some quotes from the President of the United States on January 24th. He said, quote, "It will all work out well. In particular, on behalf of the American people, I want to thank President Xi," end quote. On February 7th, he said, "I just spoke to President Xi last night. It's a very tough situation, but I think he's going to handle it. I think he's handled it really well," end quote. Through mid-March, he continued to issue tweets and statements like the ones I've just read. He began to change his tune in mid-March, but how do you deal with those quotes from the president, in effect thanking the Chinese president for his great handling of this crisis?
Well, Senator, again, my pursuit is under consumer protection laws and antitrust laws. And, you know, consumer protection laws and tort laws often account and hold these actors responsible. So for me, on behalf of all Mississippians, I'm considering what China did. I mean, they silenced medical professionals. They threatened them to deter alerting others, which meant all Mississippians were not aware of what was about to happen. They censored social media, and they nationalized the manufacturing and importing of PPE. And that's a tremendous issue for me on what they did and how they took over this and caused us to have the issues under the Consumer Protection Act. And again, they took advantage of us. They knew, and they failed to warn us.
Thank you. Just one last point. I want to join Senator Cornyn because I was the lead Democratic sponsor of the JASTA Act in suggesting that it's certainly possible for us to amend this law to protect the American people, including the people of Mississippi and all people of the United States who have suffered such disastrous harm here, if in fact your theory, Madam Attorney General, needs that kind of support. And I know you can always amend your complaint. And just to say, those lobbyists are still at it on JASTA because they're preventing just treatment of the people who suffered, the families who suffered during 9/11. And I hope that we as a committee will join together, as many of my colleagues have in the past, in continuing our bipartisan support for those 9/11 families.
Thank you very much. Senator Cruz.
Thank you, Mr. Chairman, and thank you for holding this hearing on this exceptionally important topic. I believe the Communist government of China bears enormous responsibility and enormous culpability for this global pandemic we're seeing. China's conduct can be understood at two different phases. Number one, China's conduct concerning the origin of this pandemic, and number two, China's conduct after the beginning of this outbreak. Let's talk about the origin. There are a lot of questions that have not yet been answered. What we do know is in Wuhan, China, where this pandemic began, there were not one but two state-owned and state-controlled laboratories that were both studying not just coronaviruses, but coronaviruses derived from bats, from a species of bat that is not found within 800 miles of Wuhan, the same species of bat that now the scientists tell us they believe this virus may have originated with. Senator from Connecticut responded to that, as some in the media have responded, by saying there's no evidence that this virus was created in a laboratory. I agree with you. I've heard no evidence that suggests this virus was created in a laboratory. What there is substantial evidence and circumstantial evidence to conclude is that one or both of these laboratories were studying this virus, and that the virus may have accidentally escaped from those laboratories. One of those two labs was within a few hundred yards of the wet market where the first outbreak occurred. We also know that prior to this pandemic, there were multiple U.S. State Department cables raising concerns that these labs had exceptionally shoddy security protocols, and raising concerns specifically that because of their poor security, there was a real risk of a global pandemic originating from these labs. Now, as I noted, we don't know that for sure. Part of the reason we don't know for sure is the Chinese government's behavior after the outbreak was to go into these labs and destroy all their prior samples, which I have to tell you, having litigated a lot of cases, when you see someone destroying evidence and trying to hide the scientific record, it raises a pretty strong inference that the evidence they're destroying shows something they don't want people to know. The second phase of Chinese culpability we do know more facts about, which is their cover-up. Regardless of whether this originated in nature or this was a naturally occurring virus that was being studied in a Chinese lab that escaped accidentally, regardless of which origin is true, we know that the Communist government of China actively covered up and silenced early intervention to stop this pandemic. There were heroic Chinese physicians, whistleblowers who stood up and blew the whistle on this pandemic, who stood up and said, this is really dangerous, we need to stop it. And the Chinese Communist government, they came in, they arrested the whistleblowers, they silenced them, they punished them. Had the Chinese government behaved like any responsible government, had they come in, sent in health professionals to Wuhan and quarantined the infected people, there is a very real possibility that this could have been contained as a regional outbreak rather than a global pandemic. But instead, because of the lies of the Chinese Communist government, because of the censorship, because of the cover-up, we have today over 474,000 people who have died worldwide. We have over 123,000 Americans who have died, and the Chinese Communist government bears direct responsibility for those deaths and for the trillions of dollars of economic devastation that has flowed. Now, this hearing is focused on, so what next? And my question for the witnesses is, in your judgment, what is the best path forward to achieve two things? Number one, a clear, objective, trustworthy accounting of China's culpability. That accounting would, among other things, answer the questions about the labs. Were they studying this specific coronavirus? We know they were studying coronaviruses from bats. They refused to answer whether they were studying this virus. What's the best way to achieve an accounting, number one? And number two, what's the best way to achieve accountability? Because we know they're responsible for the cover-up. What is the best way to ensure that they are held accountable for the deaths and devastation that resulted from their misconduct? And if we can go through each of the witnesses, and we'll start, Professor Keitner, you could start us, and then we'll go from there.
Can I just amend your question and say, what's the best way to deter future behavior?
Amen. Let's make it a three-part question.
Thank you, Senator Cruz. And I find myself agreeing wholeheartedly with virtually everything you've said. But the available avenue of relief that we keep hoping for is not in U.S. courts. I'm a former trial lawyer. I used to work with some tobacco partners who were in the business before I was, and so I missed that opportunity.
But if I can ask, what is the best avenue?
So I teach civil procedure and evidence. We will not be able to get in a U.S. court proceeding, even if Missouri antitrust law and consumer law applied to China, which it doesn't. We would not.
Okay, I'm going to try again to see if I can get you to answer my question about what is the best avenue. You're saying what you think isn't.
Correct, because I feel like there's a false hope and a false conception here of what a U.S. proceeding would do. What a U.S. proceeding would not do is get information. What an international investigation would do is put sufficient pressure on China in combination with the sanctions that we have already started to levy, in combination with intelligence sharing and boots on the ground, if we can send public health experts back to China where they were to begin with, and when we pulled them out, as Senator Feinstein said, that is what will give us answers, and that is what will enable us to respond to the next pandemic the way we did to Ebola.
Okay.
When it broke up in West
Professor
Africa,
Miller.
we led a response.
Senator Cruz, I think we should pursue, as my colleague suggests, an international independent commission, but I don't think that would exclude a robust inquiry by domestic institutions, a commission in the domestic space as well. I think those could operate in tandem. I am less pessimistic about the civil process's ability to both set a narrative about what needs to be accomplished and develop some evidence, or at the very least, the expertise, scientific expertise we would need to discover the truth of this case. And I would add that that combination of tools, a domestic commission, participation in an international commission, backed by civil litigation, might be the kind of framework that would point towards the last part of your questions, bringing in the chairman's question, both accountability and hope for preventing something like this happening in the future. That is, these commissions have to be backed by some legal mechanism. I would add not only the civil litigation possibility, but the legal mechanism of public international law as well. So I would like to see both investigation, but supported by the enforceability of a legal mechanism.
Okay, General Fitch.
Thank you, Senator Cruz. The strongest way that we can move forward is with legal action and discovery. We've got to hold China accountable. So if we go after them for monetary damages and civil penalties, that's going to be crucial. But what we also do is we deter. We deter continued and similar bad acts. So I am very much in favor of moving for a very strong legal posture in this regard to hold China accountable.
Thank you. That was helpful.
Senator Booker.
I'm sorry, I was told that I was after Hirono.
Yes.
Sorry,
I'm here.
Hirono, I apologize. I did it again. Senator Hirono, you're remote. Sorry, Senator Booker.
Okay.
Sorry about that. My bad.
Yeah, thank you very much.
Senator Hirono.
So I'd like to follow up a bit on the question that Senator Cruz asked about what would be the best way for us to get to an independent way to determine the cause of this virus. And I heard from, well, obviously Professor Keitner, who expounds that, and Professor Miller, who says we should also have a domestic commission. But I did hear from Attorney General Fitch that you still believe, Madam Attorney General, that a lawsuit is the best way to proceed?
Thank you, Senator. I believe that is the strongest pathway we have moving forward. But as we all know, this has affected everyone. Certainly a commission board to study would be extremely important, but to move forward right now, we need to hold them accountable through legal action, discovery, monetary damages, penalties, and then also deter their action.
I understand about deterrence, the deterrence value of various kinds of lawsuits. On the other hand, Professor Keitner has said that it is not particularly likely that you will prevail in that lawsuit. So then I would say that an independent panel would be a really good way to determine what China was doing. And nobody is sitting here saying that China is without fault, although I have to say that President Trump did say he thanked President Xi Jinping for the way China was handling the coronavirus situation in China. Now, Secretary Azar declared COVID-19 to be a public health emergency in January of this year. And I'd like to ask the panel, when do you think the president's responsibility kicks in to deal with the healthcare crisis in our own country? I'll start with Professor Keitner.
Thank you, Senator. And indeed, the causation questions are very complex here. As Professor Miller also indicated in his report, if there were an award, so let's fast forward, it would be discounted by all of the intervening factors between the outbreak of the virus.
Okay, I don't mean to interrupt you, Professor, but really my question is, when does the president's responsibility kick in, regardless of what happens in the lawsuit? But the declaration of a public health emergency was in January of this year, and when does the president's responsibility kick in?
Yes, sorry, it kicks in prior to that, Senator, as soon as there were reports in our intelligence briefings that a new outbreak was emerging.
Attorney General Fitch?
Thank you, Senator. I'm focusing on, my suit focuses on their actions once we knew about the infection. So we moved forward from the time that we knew that we were being compromised and unaware of what was happening, and then we knew what was happening with the PPE and the hoarding, and then the selling of the substandard equipment back to America, and particularly Mississippi.
Professor Miller, when does the president's responsibility or the administration's responsibility kick in once his own secretary declares that there's a health emergency?
Yeah, here I agree with my colleague. I view this as a political question, really. When you refer to the president's responsibility, it's a question of his political responsibility to the people of the United States to act. And if legislation was necessary to trigger some authority, then it would be the president's responsibility to seek support for that kind of legislation. But as soon as the American public was compromised, jeopardized, or threatened by something like this, then the president needs to act.
Yeah, that was before January. So, Attorney General Fitch, I note that in your complaint you say that China was engaging in unfair and deceptive trade practices relating to hoarding of necessary personal protective equipment and reselling substandard PPE to a desperate world at inflated prices. Were you aware that in January of this year, the Trump administration turned down an offer from a U.S. manufacturer to produce millions of N95 masks in America? These would be PPEs. Were you aware of that?
Not about the president and about China's acts. I've been very aware of when it affected Mississippians. We knew when the silencing began, the cover-up, the hoarding. So we utilized that data as we move forward.
The thing is that when you claim unfair and deceptive trade practices, that is basically consumer law. that is basically antitrust law, you do have to show that somehow China was able to corner the market on PPE. And if there was a U.S. manufacturer perfectly capable of manufacturing this kind of equipment, I think that you would really have a hard time making an antitrust claim there. So, let me, I just have to wonder whether, Mr. Attorney General, you think that the president did what he should do in terms of his own response. I realize you're going after China, but what about, in your view, was the president's response to this virus, this pandemic, adequate in your view?
And so I'm proceeding along the lines of my lawsuit on the Consumer Protection Act for Mississippians and the Mississippi Antitrust Act. We are moving forward in that regard. We can show that China did engage in unfair and deceptive acts. Also under the antitrust, we're looking at how they were engaged in restraining or attempting to restrain freedom of trade of PPE, and then by hoarding it and not providing that to Mississippians. So we're looking at how they created a very unjust environment. And
what I get, Ms. Attorney General, is you are having a really hard time. I think there is a general consensus that our own country could have done a lot more so that we don't see tens of millions of people unemployed. In Mississippi also, you have thousands, and as well as over 100,000 people dying. I think there's enough blame to go around, and as far as your lawsuit, I used to practice antitrust law myself, and I think it would be a little bit difficult for you to show that there was some sort of restraint on trade. So thank you very much.
Thank you, Senator Rono. Senator Hawley, Ernst, I apologize.
Thank you, Mr. Chairman. A study that was...
Wait a minute, it is Hawley, I'm sorry.
Sorry.
Apologize. Getting used to
Great,
people.
thank you, Mr.
Yeah.
Thank you, Mr. Chairman.
My bad.
Thank you. General Fitch, thanks very much for being here, and to all of the witnesses for being here. General Fitch, I just want to give you an opportunity to respond a little bit further to some of the questions that you were just being asked. I'm interested to hear that now it appears, at least in the view of some of my Democrat colleagues, that the United States and China are roughly equivalent bad actors when it comes to the coronavirus. Wow, that sounds a lot like the Chinese Communist Party propaganda that we've had jammed down our throats for the last several months, which is really incredible. Is it your view, General, that China intentionally suppressed information about the nature of this disease?
Thank you, Senator Hawley. And I do respectfully disagree with the senator, because we do have a case. And it's important that we move forward with this case. And I believe under our Mississippi laws, we will prevail. But if we don't act, then we've been irresponsible by not acting on behalf of Americans in Mississippi. So that's why I'm bringing this suit. And I believe it will certainly move forward in a monetary way, but it is an important deterrent.
Absolutely. And we know that China lied about the origins of this virus. We know that they lied about what they knew and when they knew it. We know that they'd identified cases at least as early as December, right? And did not inform the public, didn't inform their own public, jailed the doctors who were trying to blow the whistle, suppressed evidence, lied to the World Health Organization, although they later colluded with the WHO to get them to sweep that under the rug. So I have to say, I think your case is very strong. And as somebody who has been targeted by the Chinese regime, and proudly so, the Chinese Communist Party has threatened to sanction me personally and to sanction my state, the state of Missouri. I'm proud of what you're doing. I'm proud of the fact that the state of Missouri is right there with you. Missouri has also brought suit against the regime in Beijing. And I just want to thank you for your leadership on this. Let me just ask a little bit about your suit. Senator Blumenthal was touching on this earlier. You were brought suit under the commercial activities exception currently to the Foreign Sovereign Immunities Act. Have I got that right?
Yes, that's correct, Senator.
And so the commercial exception, and you've made a good argument for it, I have to say, the courts traditionally construe that fairly narrowly. Is that fair to say?
That's true, but we believe our action fits squarely within that exception.
I do too. I have to say I do too. But let me just ask you this. If Congress were to take action, such as the bill that I have proposed, that would make it very clear that states and individuals had an action in court, an actionable case in court under the Foreign Sovereign Immunities Act to make clear that there's no immunity for China in this set of circumstances, would you welcome that additional clarification for Congress?
Absolutely, Senator. Any additional exceptions would provide broader avenues for states and individuals to seek justice, and there's no reason to restrict. So thank you for continuing to pursue adding additional tools for us.
Absolutely. And my bill also expressly states that states should have a right to sue for China's role in spreading the coronavirus. China will have no immunity from those suits, and it gives our courts, authorization to freeze Chinese assets in this country in order to make sure that the states and the people you represent can get judgment if and when you win. Would that be helpful to you to have courts have that sort of authority to be able to attach those assets in order to award damages?
Yes, Senator, that would be extremely helpful to us as we move on to collect those monetary damages and those civil penalties.
Very good, thank you. Mr. Miller, in the time that I've got remaining here, and thank you for being here, and I've enjoyed your testimony. Can you it's my understanding from your testimony today and your previous work that part of your argument here is that the prospect of state and private suits against China will help bring China to the negotiation table. It creates a form of leverage that is useful from an international relations perspective. Have I got your basic position right? Do you want to clarify that for us?
Yeah, I don't want to excuse or eliminate the possibility that these civil suits might actually generate some measure of justice for victims by way of civil remedy, but they would have the additional force of supplementing international negotiations and international law measures. And we've seen evidence of that repeatedly, whether we're talking about suits leveled against Iran and ultimate negotiations leading to settlement there. I expect that the suits proceeding against Saudi Arabia, for example, based on the atrocities of 9/11, will also have some effect in the international law negotiations, the diplomatic negotiations. And that will be true with respect to the East African embassy bombings and those suits as well. I don't see why this civil law remedy can't also be a contribution to those public international law mechanisms.
Very good. Well said, Mr. Miller. I think that's very well said. I agree with you completely, and I think that puts the case very strongly. Thank you, Mr. Chairman.
Thank you. Senator Booker.
Thank you very much, Mr. Chairman. I'd like to focus my questions today to Professor Keitner, just to make it easier, if you don't mind. I just find it exciting that there is so much bipartisan sentiment agreement on just, frankly, how we know that China has been one of the malign forces on the planet in terms of their state-sponsored espionage in our country. They're forcing our companies to share technology and secrets. They're corporate espionage. I can go on and on and on. Currency manipulation. China is a bad actor that is threatening in so many ways our economy. And now I want to talk to you a little bit about them threatening our health. So we know China, this authoritarian nation, it's a system in which information flow is deeply restricted. There is no doubt that China should have been more transparent regarding the extremely dangerous nature of this virus and the urgency for a global response. Indeed, as early as November and December of last year, there was evidence of the emergence of an atypical pneumonia linked to a wholesale market in China. In late December, members of the medical community were reprimanded in China by the state for speaking out about the truth of what was happening as they tried to put a chill on information emerging. It's clear that China's early response to COVID-19 had a horrific and lethal consequence for the United States and the rest of the world. But the problems go deeper than China's immediate response to COVID-19 itself. Back in April, I led a bipartisan letter with Chairman Lindsey Graham and many of my colleagues calling for an immediate global ban on live wildlife markets, so-called wet markets, and the international trade of wildlife. This is the kind of market where COVID-19 outbreak is believed to have originated, as you know, and as other of my colleagues have been bringing up. Vendors, shoppers, and live and dead animals of different species all jammed into really close quarters. And the markets are therefore ideal and terrible places for diseases to jump, so-called zoonotic diseases to jump to humans. And so, Professor Keitner, just a few quick questions. What legislative tools can Congress use to try to push for the global ban on live wildlife markets and the international wildlife trade? And the second part of this question is, earlier this year, China actually announced that it was banning the trade and consumption of wild animals, but a number of analyses show that China's ban has a significant amount of loopholes, including the exception for trading wildlife for medical purposes, so-called medical purposes. What tools, again, can Congress use to push China and, frankly, other countries to impose strong, serious bans on wildlife markets related to trading to really save potential pandemics in the future?
Thank you, Senator, and I commend you and Senator Graham for your letter and for that initiative. And I think the international forum to which you've addressed that letter, the idea that we need international cooperation, and then if the United States were willing to take a step forward and make whatever agreed commitments countries signed up for, to make them enforceable, which is something that we are often hesitant to do because of, what's sauce for the goose is sauce for the gander. We also want to, preserve our freedom of maneuver. But if we were able to negotiate the terms of a treaty and make those enforceable, we could shame China, and Congress can take a leading role, in particular through your appropriations power, in ensuring that sufficient funding went to the bodies that were administering that new regime.
Thank you so much. And, it's problematic because you see this cycle happening. In the SARS outbreak in 2003, China implemented a narrow ban on wildlife trading, but it was temporary, and China later rolled it back. And so this is really a time that we should be leading a global effort against this. And so real quick, the last question is, it's clear that China has been downplaying and obfuscating the threat posed by COVID-19, as we said early on, and the ways that have had lasting and deadly impacts. But we have to also acknowledge that is not the only reason why we see death rates in our country that are so staggeringly high, especially relative to a lot of our peer nations. The World Health Organization in January declared COVID-19 to be a public health emergency of international concern, but it really took 6 weeks for us as a nation to declare it a national emergency, 6 weeks for the Trump administration to act. And the first case of COVID-19 in the United States was in January of 21st. Taiwan's first reported case was actually on the exact same day. South Korea was 1 day earlier. All three countries have had the same information regarding the genetic characteristics and the lethality of the virus. Taiwan has lost 7 people to COVID-19. South Korea, 281. This country is now past 122,000 people. And so I know the committee is considering proposals to amend the Foreign Sovereign Immunities Act to enable COVID-related civil rights lawsuits to proceed in foreign nations. But you actually wrote in your testimony, I think, something that we should highlight, which was, I quote, the catalog of the shortcomings in U.S., local, state, and federal responses to the threat that was reportedly highlighted by the Intelligence Committee in the President's daily briefing as mid-January brings up a whole bunch of complications. And so the one question I'd say is, can you just explain really quick, I want you to put it on the record, why the approach outlined in these proposals is misguided because of the potential for engaging us in protracted litigation, literally having to be subject to discovery into errors made by the Trump administration and other governmental entities. Sovereign immunity is based on the idea of reciprocity. And we respect the principle of sovereign immunity in our courts, and in return, we expect the same in other countries. Doesn't this dredge up a lot of complications and vulnerabilities to mistakes that were made by the Trump administration?
Thank you, Senator. On the specific point of discovery, because I know our time is short, I will say, of course, discovery is a two-way street, and information is much more readily available from U.S. sources, so that would absolutely come out in court if we ever got to that point, with the only exception of course, classified information, which would be another problem for the plaintiffs, as we have seen in the ongoing 9/11 litigation.
Thank you very much. Mr. Chairman, thank you for your indulgence.
Thank you. Senator Ernst.
Thank you very much. And just in response to that too, hindsight's always 20/20. It is always 20/20. And faced with a pandemic, I think this administration did a admirable job in trying to do the absolute best they can to protect our population when the Chinese government was not forthcoming with information on how we could protect ourselves. I think that lies with the Chinese government. So I know that this administration faced some pretty serious criticism very early on in the pandemic for not allowing people to travel from affected countries to our country. So many things were brought up about that period of time, a huge amount of criticism heaped on this administration, and yet it was the right thing to do. Again, hindsight is 2020. Now we have those that are questioning why didn't he do this sooner? Well, maybe because of all the criticism that was being placed upon the administration for trying to do the right thing in the first place. So a study published in March out of the University of Southampton in the United Kingdom, I think we've talked a lot about that, indicated that if those Chinese authorities had acted 3 weeks earlier than they did, the number of coronavirus cases could have been reduced by 95%, and its geographic spread would have been severely limited. And so let's just think about that a little bit. We know that China vastly downplayed, again, the emergence of the coronavirus as early as the fall of 2019. And if China had acted just 3 weeks earlier, tens of thousands of American lives could have been saved, and potentially millions of Americans could still be going to work. So the Chinese government's lying and obstructionism hasn't just impacted our ability to respond to the virus, it's also escalated to the level of blatant theft with the goal to erode U.S. military leadership. In April, the leader of U.S. PACOM, Pacific Command, Admiral Davidson, he testified before Congress that he believed China was, quote, stealing technology in just about every domain and trying to use it to their advantage, end quote. This is in addition to ongoing cyber operations targeting our intellectual property. China has absolutely no respect for the law. They will do anything they can to get a leg up, and whether that's stealing sensitive military secrets or letting people die to avoid taking responsibility for the spread of COVID-19. So what I want to see, and I believe what a majority of Iowans want to see too, is for China to pay for this deadly obstruction. To allow the Chinese Communist Party to go unpunished would be a travesty, and it would result in this cycle of lying to go on. And so thank you, Mr. Chairman, for having this hearing and attempting to tackle the issue. I'm also glad that throughout Congress, we are having a conversation about how we can best bring the manufacturing of critical medical supplies home. I'm working on some legislation on that front and look forward to ensuring that if this happens again, and it will, I'm sure, if the Communist Chinese Party continues on like they have, that we're not subject to the whims of China. So I'd like to start my question with Attorney General Fitch. And thank you so much, Attorney General, for being with us today and for being the first woman to serve as AG of Mississippi. Thank you for being a strong role model. So Attorney General, Mississippi was one of the first states to file suit against China due to their failure to inform us about COVID-19. So we've heard a lot about retaliation lawsuits regarding COVID-19, and I've even heard some really insane statements coming out that their legislature would be willing to allow Chinese actors to, of course, then turn around and sue Americans. So can you talk to me a little bit about retaliation that China might have against your state? And if so, what can Congress do to help alleviate that concern?
Thank you, Senator Ernst. I appreciate that. And it's an honor to serve as the first woman Attorney General and represent all Mississippians. Certainly, China is known for repetitive bad actions, and we have to hold them accountable. Certainly, they will probably come after all of us who are looking to do that. But we're prepared, and if we continue to hold them accountable, if we go for monetary damages and civil penalties, we begin the deterrent process, they will stop. And it'll be a sign to all the nations that we will not tolerate that on behalf of Americans, Mississippians, everyone across our many states. So I understand that there's that possibility, but we have to stand strong and we have to stand united.
Yeah, thank you so much, Attorney General. My time has expired, but China has been a darn bad actor for a very long time. And I think Americans are sick and tired of taking it in the shorts from China. So it's about time that we stand up for ourselves and let them know that we will not tolerate it any longer. Thank you, Mr. Chair.
Yeah, I don't like China's chances in Mississippi, given what I've heard from the Attorney General. Senator Blackburn.
Thank you, Mr. Chairman. And I want to thank you for this hearing today and our witnesses for being here. You know, it's so interesting to hear this conversation. And I think we all know that this year, China, this was in February, after the Wall Street Journal put an article up, it was titled, "China is the real sick man of Asia." Then what did China do? They expelled 3 journalists. Then you have the fact that we have found out, as we've talked to activists and people on the ground there in China, they knew they had this pandemic on their hands for 51 days. They chose not to take an action. What did they do? They were buying up and hoarding PPE. And as you've heard earlier from others, they were locking people in their apartments. They were leaving them to die. They had 3,000 cases. They wouldn't let, before they said anything, they wouldn't let you travel in China, but you could get on a plane in Wuhan and go anywhere else on the face of the earth, and they were fine with that. So you have to ask yourself, why were they doing this? Now, there's been talk about legislation, and I'm so grateful to the chairman for having the hearing on this today. And we have referenced JASTA that we did in 2016 when we made that exception for the 3,000 families that were adversely impacted, the loss of life, 3,000 lives on 9/11. And it allowed those September 11th families to seek that compensation from Saudi Arabia. Now think about this. As of this week, we have 122,000 lives that have been lost in this country. And why? Because of this virus. And as the chairman said, we don't know if it came from the lab, if it came from the wet market. We do know that it came from Wuhan, China. So this is why my colleagues have joined me on the Stop COVID Act that would again provide this amending of the Foreign Sovereign Immunities Act and give Americans their day in court. So AG Fitch, first of all, I want to thank you for stepping up and doing this. And I want to ask you just a couple of things. Do you think other states are going to join you in this lawsuit? And how would state attorneys generals and then the American people, their citizens, benefit from having another tool in the toolbox so that they could seek that compensation from the Chinese Communist Party?
Thank you, Senator Blackburn. We have to hold them accountable. We have to be very strong in our actions. I think that more attorneys general will continue to be a part of it. We have already sent a letter of 21 attorneys general requesting continued action legislation to give us more tools to proceed. It's certainly about monetary compensation and civil penalties, but it truly goes back to the deterrence. China needs to know that America, we're going to use every tool at our disposal. And the more that you're able to provide through additional exceptions and legislation is extremely critical. Helps us hold them accountable because we're not going to allow them to wreak havoc on our people like they've done with this pandemic. So I think you'll see more and more AGs move forward with that. This is a very malicious behavior on the behalf of China. And so we have got to, again, look at every avenue that we can and make them be on notice that they cannot do harm to us.
So there are 21 attorneys general that are looking at seeking some type restitution. Is that what you just said?
That's correct, Senator. We have
Okay.
letters requesting additional legislation to help provide ways to go after and hold China accountable.
Okay, that is helpful to us, and we hope by getting the Stop COVID Act passed that we can provide another tool in the toolbox for that. Professor Miller, I want to talk with you just a minute about China responsibility, and I appreciate your article on China's responsibility for the global pandemic. And you discuss how a famous 1920s international law case has great implications for holding China accountable today. And in that case, Canada paid reparations to the US after toxins from a Canadian zinc smelter destroyed parts of the Pacific Northwest. You wrote, and I'm quoting, "If Canada had good environmental laws in place, the smelter wouldn't be polluting and wouldn't have done harm in the US," end quote. Likewise, and again quoting, "If China had maintained an adequate food safety regulatory regime, the harm wouldn't have been spread," end quote. So talk for just a minute about how Chinese citizens would benefit by our holding China accountable for what they have done, not only to the US, but to other nations.
Yes, Senator, thank you. The arguments that I'm making point to, and frankly, this draws on the questions of Senator Booker. The arguments I'm making is that the sale of wildlife in China has been a repeated cause of the emergence of these viral outbreaks and potentially eventual pandemics. But to talk about that is really to talk about a regulatory failure on the part of China to maintain an adequate and an effective food safety regulatory regime. This is regulatory failure, just as it was regulatory failure for Canada to maintain a proper environmental and pollution abatement regime. If that's the case, then it's not only American citizens that would benefit from some accountability with respect to a regulatory failure like that, but in the very first instance, it's going to be Chinese citizens that will be the beneficiaries of our efforts here. That is, they're first in line for exposure to these outbreaks. And as we've heard repeatedly today from all sides, that they're at great risk of human rights violations should an outbreak take place and the regime there seek to try to control it. And in this sense, the attempt to hold China accountable for its regulatory failure, its regulatory neglect, speaks first and foremost to the interests of Chinese citizens.
Thank you. I think our time is, would you like to finish up, Senator Blackburn?
No, thank you, Mr. Chairman.
Thank you for your work on producing a product that the committee will consider. Thank you all to the witnesses. I appreciate what you brought to the table here. We're not a court of law, so we're not going to decide the case, and we can all have our own opinions about who's to blame in terms of the next election cycle. My goal is to put more tools on the table to make sure that China understands enough is enough, and what we've done in the past hasn't worked. So it's been a very helpful hearing. We'll hold the record open the appropriate period of time for additional comments and questions, and the hearing's adjourned. Thank you all, and Attorney General from Mississippi, you were great. Thank you very much. Thank you all.
Thank you.